Yes, Mr. Horsey.
So, my lady, my third ground is to do with ouster, and I don't know whether this will come as a pleasure or not, but I'm not going to ask you in this appeal to resolve that issue which is left floating in the Moncrief case about whether the test for ouster is a narrow one or a wide one. I'm going to invite you to assume, in the respondent's favour, that the test is the narrow one put forward by Lord Scott, which Lord Neuberger had question marks about. But assuming I'm setting myself the challenge of showing that even on that narrow approach, the ouster principle would be offended by recognising the rights in this case as easements. Now, just to remind, I don't know whether it's helpful to turn it up or not. I think I can read you the test. It's only a sentence. It's whether the servient owner retains possession and, subject to the reasonable user of the right in question, control of the servient land. Now, lady, you've got my submissions, which I'm not going to go back over, about what this grant envisaged. We say it was a continuous, active, operational intervention by the servient owner of the facilities to secure their provision free of charge to the dominant owners. Now, viewing that through the prism of control, this far exceeds what is compatible with Lord Scott's narrow ouster principle. What one has to imagine is that that degree of control comes to be exercised by the dominant owner instead of the servient owner over his own land.
But why does one have to imagine that? If the contemplation was that probably the servient owner would be running, let's say, the golf course, the fact that if he doesn't, the easement gives the dominant owner the right to come in and do what's necessary, why should that assumption govern whether there's an ouster?
Because the way Lord Scott tests, as I understand it, seems to work, is to ask whether the control that's associated with using the rights that were granted is sufficient to oust the servient owner. So one has to imagine that it's the dominant owner who is doing the things which amount to acts of control or don't. And in some cases, they won't be acts of control. When you go onto somebody else's land to walk across it, the degree of control you exercise over the land it's negligible, if present at all.
So do you test it by the fullest possible use of the right granted together with any ancillary rights? I don't
need, I think, to set the bar that high. I'm not sure it needs to be the fullest possible for my purposes. Certainly the approach I'm taking is simply to go back to the conveyance and ask what control would be needed to give effect to the use contemplated. And the use contemplated would require control and management and operation of a golf course, for example.
This is on the footing that the alleged easement carries with it an obligation to provide facilities.
But that's what was expected, yes.
Yes, I mean, so this submission depends on your being right about that.
No, it doesn't depend on that.
Okay.
Doesn't at all depend on that. This submission is completely separate of that proposition. It asks what would be involved by the dominant owners if they do the thing which I say, but your lordship questions, it was envisaged that the servient owner would do. So,
I run the facility.
Yes, in order for the, but whether that was an obligation or not is separate from the question of what was envisaged. Let me put it this way: if, in order to enjoy the golf course, which was clearly promised, it's described as a championship golf course, the other facilities are of a comparable standard. In order to enjoy the use of that as a golf course, one needs complete control of it. You can't have random flights of players going off and hitting balls around. It would be, apart from anything else, it would be dangerous to do that. It's absolutely intrinsic to the use of a golf course that control needs to be taken over the whole of it, both as regards timetabling and also as regards cleaning up after people take.
Sure is more. I mean, there are lots of golf courses where all sorts of uses take place and people get on with it, and that's works. I mean, surely, isn't this really much more tied up with your whole facilities point? I mean,
It's
what
certainly
was
related,
contemplated here
my Lord.
was not a free-for-all, but that they would provide a golf course, which indeed they had, and which they had undertaken to maintain. The problem is that the maintenance covenant didn't work because it was designed for a leasehold situation, but ended up in a freehold situation. And so we got this totally artificial situation where we're trying to make one bit of the equation work without the other.
Well, Lord, in a nutshell, that's right. It's not separate from the points that I've been making about use of the facilities. I can put it in this way. The right granted was not a right to use land to play golf. It's not a right of that kind. It's not expressed in that way. It's a right to use the golf course, to use the swimming pool. The whole language of the grant is emphatic and pointing in the same direction all the time, which is, as my Lord Carnwath has described it. And if you then imagine that the servient owner steps away from the picture, somebody else has to do all the things which enable that contemplated use to come into being. It's the dominant owner who's going to do it. And the dominant owners need that same degree of control, which I respectfully say is clearly in excess of what Lord Scott...
Can you be a bit more specific about what acts of control you envisage which would be repugnant to the concept of an easement?
For example, on the day when frost is present on the ground, the course marshal may have to decide whether it is appropriate to open the course or not. Even when frost is not an impediment, other conditions may supervene, which mean that the course marshal declares that it is unsafe to play. Equally, in many golf courses, visibility is an issue. It may even be an attraction of the golf course that you cannot, from where you are hitting the ball, see the entirety of the ground in front of the hole to which you are aiming. There may be deliberate obstructions, and there may also be people there.
Now, I'm not quite sure in those circumstances why you denied the suggestion I put to you a few moments ago that this submission depends upon the correctness of the submission you made this morning about the obligation to provide golf course marshals and so on.
My Lord, I've distinguished in the answer I gave you, and I hope I'm right to draw this distinction between two situations. The one is in which you are with me to the extent that the paradigm case envisaged by the grant was as I've described it, but not with me to the extent that the paradigm case was enforceable contractually. The argument I'm now advancing applies in that situation, as well as in the other situation, which I prefer and advance, that as well as that being the paradigm case, it is also the enforceable case under the transfer.
If we were to conclude that the rights of the dominant tenement was simply to make use of such facilities as were available and nothing more, the submission that you're currently making would fall away, would it not?
Well, it would. In that case, I would suggest that the problem would be to identify what is the limit of the right of the dominant owner. And that comes back to my Lord Briggs's question about whether I'm asking what is the maximum use that could be made of these rights. Because in that situation, one is left wondering, well, what would there be to prevent the dominant owners from controlling the use of the golf course and the swimming pool and so on in the way I have just described as it being incumbent on the servient owner under the contractual situation? And the answer, I suggest, is there would be nothing to stop them doing that. It would not be possible to say that it was incompatible with what had been granted to them. The problem is that in doing so, they would be usurping the control which of the servient owner to a degree in excess of that which Lord Scott contemplated. I hope that answers my Lord's question. Whether it's acceptable to your Lordship or not, of course, we need to consider, but I don't think I can immediately improve on that as an answer. So we say that the dominant owners, even if they clubbed together to take control of the golf course, couldn't have a situation where the owner would pop in on his own or allow his friends to come in and play golf because of the danger that it would present. The golf course is the clearest example, but analogous examples can readily be posited in relation to the other facilities in question. So, Lord, Milady, those are grounds 1, 2 and 3. I don't want to add to what I've said in writing about ground 4, but before I leave this part of the case, I wanted to go back, in light of particularly of some of the questions from the court, to that part of our case where we identify some of the reasons why one needs to be careful about being too casual about property rights in this field. In our case, we've dealt with the points that we are aware of in paragraph 64 to 74, which is memory stick page 209.
209.
My lord, yes. And I've shown you paragraph 65. I've shown you the origin of our submission based on the Law Commission's work. In paragraph 66, we list matters also mentioned by the Law Commission as problematic about easements, including section 62. This is the trap for the unwary, which we've explained in paragraph 67. A mere personal license can come to be elevated into a property right if it has the characteristics of an easement. Shouldn't be relaxed about recognising things as easements. They may be difficult to detect because they can be overriding interests, they exist in perpetuity and are impossible to get rid of, and there's no mechanism, statutory or otherwise, for their modification. So that's paragraph 66 and 67. Paragraph 68 and 69 and 70 are also important, my lady, because of the point that's here made about subdivision. It's intrinsic to the law of easements that your use of the servient land is limited by the capacity or needs of the dominant tenement. That is the intrinsic limitation on its use. In a case such as the present, there is no restriction on an infinite subdivision of the dominant land. How then does one limit how many people can come on and swim in the swimming pool or play golf on the golf course and so on? The problem arises because there is nothing to connect the use which has been granted with the use, actual use of the dominant land. The disconnect between those two things means that there is no way of controlling the burden which may arise on the servient tenement. And those are the points in a nutshell dealt with in paragraph 68, 69 to 70. In paragraph 71, we've made this...
So just pausing a moment. The points you make about section 62 and so on are taken from the Law Commission's report, which we have at supplementary page 64. But they were in turn taken from Gale on easements, where Gale on easements refers to the difficulties of, well, particularly section 62 and the implications of that, and also the fact that there's no power to modify easements, unlike restrictive covenants.
Yes.
Is there was a final report of the law?
There is. I think we've got some extracts of it in the bundle, and I haven't got a note of where...
I'm not asking you to look at it. I'm just wondering whether there's anything in it which assists...
I think it's tab 86, and I'll look at it again overnight, but my recollection is that it didn't take matters so far beyond the consultation paper as to justify burdening you with more than is in tab 86.
Fine.
Yes, 1966.
Yeah, well, I know.
What?
1966 in the...
Yeah, no, no.
So, milady, then in paragraph 71, you remember I showed you that part of Moncrief where Lord Newburger expressed concern about losing sight of the importance of preserving the difference between contractual licenses and proprietary rights, and I have to submit that the same danger arises equally in the present context. So we say the Law Commission were right to take the view that they did, and in paragraph 73 we point out that there's actually no need to relax this requirement.
There's nothing in McGarry and Wade on this.
There's nothing that takes matters any further. In fact, I won't say what I was about to say about McGarry and Wade on this.
Well, no, it's only that I know Charles Harpen felt quite strongly about this sort of issue, but
no,
to find its way into
I don't think again, we'll look at it again overnight, but if it had been illuminating, I would have put it in the
Yes,
case. Paragraph 73 is our submission that one stands back and asks, why should one relax this requirement in the way the respondents suggest? One is immediately confronted with the sort of rhetorical answer that they could have done what they wanted to do by using a lease. There doesn't seem to be any dispute about that. A leasehold arrangement could have worked. They, for reasons that aren't explained, decided to try to achieve, through a freehold mechanism, using concepts of real property, concepts that belong in landlord and tenant law, which are supported by privity of estate, backed up by the Grantees of Reversions Act 1540, the Landlord and Tenant Act, the Law of Property Act 1925, sections 141 and 142, which attach covenants to the term and to the reversion, creating a presumption of enforceability, subject to exceptions which the courts have fashioned. Whereas in property law, in real property law, the position is the exact reverse. In property law, as a matter of real property, the law is hostile to recognising rights as perpetual, with the limited exceptions that have been carved out. So this mechanism of leasehold law was rejected for reasons which are unexplained, but which, I mean, it's not as if the respondents were able to come to your ladyship's court and say there is, underneath this appeal, a whole number of timeshare arrangements up and down the country that are at risk. That's not being suggested. And it may be that other timeshare arrangements have been set up properly using leases. One doesn't know. But one can't assume that there is a significant risk to anybody lying behind allowing the appeal as we suggest it should be allowed. And we refer also in paragraph 74 to the proposition that there's nothing inherently unjust about allowing the appeal in the way that suggested. So I thought it might be helpful, before I left that part of the case, to remind the court that there are powerful reasons why one should not simply look at this as a matter, so to speak, of contract law, unplugged from important, long-standing, core concepts of real property. To do so is potentially a hazardous course, I respectfully suggest. Then I turn to the respondent's cross-appeal, as brief as I may. The cross-appeal raises a number of interpretation points, which in our case are dealt with in paragraphs 121 and following. I've made oral submissions this morning about how one should look at the transfer, and those submissions were intended to cover this part of the cross-appeal. And I think at this stage, rather than reading it all out, may I just remind the court of what we say in paragraphs 121 through to 133, and padded out by the additional submissions I made orally this morning. The additional point that arises is in relation to one of my learned friend's arguments, which is that this swimming pool, which was filled in, I think, in about 2000, can be regarded as having been replaced by the one which was provided in about 2008 in response to an order made by Judge Pelling, litigation between the landlord and tenants of the Mansion House apartments. And one of the ways in which it's put is that to find otherwise would be to allow the owner of the swimming pool to take advantage of its own wrong, sort of breach of the own wrong point. And another and related way in which this point seems to be put is by analogy with the right to deviate around an obstruction of a highway. It seems to be suggested that's in some way analogous. And I did just want to call attention to the submissions we've made in paragraphs 125, 126 and 128. including particularly on this point about the right to deviate and get around an obstruction at 128, what my learned friend is praying...
You have an easy page number.
Oh, sorry. It's
228.
Yes, 228. 228. It is a remedy of self-help. We deal with this in 1282, which the courts have always confined. We've mentioned Burton and Winters. This hasn't been answered. To simple cases such as an overhanging branch or an encroaching root which wouldn't justify the expense of legal proceedings, and urgent cases which require an immediate remedy, and as a remedy which should be regarded with great jealousy. And the situation here is that the swimming pool got filled in about 2000, and these respondents never did a single thing about it. Nothing. What happened in 2006 is that the leasehold owners of the mansion got together and sued the landlord under a covenant to maintain, a positive covenant to maintain. The court granted specific performance of that positive covenant in favour of the leaseholders. Nothing to do with any effort on the part of these respondents to vindicate any legal right.
Why does any of this matter?
Well,
we're really concerned, aren't we, with determining whether either the reference to the swimming pool means any swimming pool on the land, or if it doesn't, whether the pool in its new location constitutes a sporting or recreational facility.
yes, I agree, my lord. If I
That's the only point.
I think, I shouldn't say think, I submit that actually that is the only sort of arguable point that could be taken. It's the interpretation point. But just to complete the story, so to speak, this way in which the respondents put their case in relation to the swimming pool is seeking, as it were, to capitalise on somebody else's rights. Somebody else has established, or did establish, the right to have an indoor swimming pool, independently of anything asserted by the respondents. And so it's never been established that the respondents ever suffered an interference with any use of the swimming pool. It's never been established that they had some continuing use which was interfered with by the filling in of the swimming pool. But even if one looks on the filling in of the swimming pool as an interference, their remedy was to sue on it, to get back the swimming pool that they had lost. What is wrong with that as a remedy? If they have an easement over the outdoor swimming pool, lady, we don't say it's been lost. It's still there. It might be too late for them to do anything about it now, but they didn't lose the easement just because it was filled in. So why do they need an indoor swimming pool? The reason they need it is because they have not clubbed together in the way they say they are entitled to provide one. But I repeat, I do respectfully agree with my learned friend, with my Lord's assumption that really the only properly arguable part of this bit of the cross appeal turns on the interpretation of the grant. And I mean, I've made brief submissions on that. It's probably unproductive for me to go back over that. We say that you can't, or certainly shouldn't, interpret the transfer otherwise than as the Court of Appeal did. There is a point of tedious detail about the location of the swimming pool in the house. The statement of agreed facts and issues records that in the part of the basement where the swimming pool came to be constructed, there was previously no recreational sporting facility. We've dealt with this in our case at paragraphs 132 to 133. In their printed case, they're not in their grounds. The respondents say, actually, the swimming pool was put into a part of the basement that was affected by recreational facilities. I'm not sure how your ladyship proposes to deal with that. We rely on the agreed statement. Then finally, on the substance of the appeal is the matter of quantum merit. The quantum merit aspect of the matter arises on the pleadings in a pretty straightforward way. There's, I think, a single paragraph of the pleadings on my client's side which seeks quantum merit in the event it turns out that the rights were not exercisable as easements. And the response in the pleading for my learned friend's side was as simple as saying, well, it stands or falls by reference to whether these rights are easements or not. That was the only point taken. No other point was advanced. So things seem rather to have mushroomed since then. I need briefly to start by just checking a point off. The grounds of cross-appeal in page 66 in the memory stick number the foot of the page made a complaint that the Court of Appeal had disposed of the quantum merit arguments without addressing an argument that's referred to higher up on the page. And we explained in our case that, with all due respect, is simply wrong. We've dealt with this in our case at paragraphs 141 to 146, that's pages 233 to 234. That's not been answered by the respondents, and as I read their case, this line of attack is not pursued. They're not making the complaint that the Court of Appeal didn't.
Sorry, bottom line, what are you saying we should do about the quantum merit if we get to that
I
point?
think one can cross off as an argument the idea that the Court of Appeal didn't deal with quantum merit, which I had understood to be, it didn't deal with the argument that was raised in paragraph 22 of the grounds.
I understand your thing. I'm just trying to get to the bottom line. I mean, the obvious thing, if we get to that point, is to send it back to someone else to deal with it, isn't it?
Yeah, the bottom line on quantum merit, my lord, is this. The Court of Appeal ordered there should be an inquiry in front of the master. And I can't understand how the matter has come into the Supreme Court. Everything...
No, your submission is that's the thing to do, is it?
Yes. And the idea that at this stage one can litigate the detail of a quantum merit claim, the parameters, is, I suggest, far-fetched. The way in which my learned friend seeks to deal with this is to say that in principle there should be no quantum merit for various reasons which are not. As I understand it, what it comes down to is a suggestion that the respondents may have been using the facilities unaware that they might one day have to pay for doing so. Well, we have given in our case, between paragraphs 135 and 146, including by reference to an authority, an explanation as to why that is not supportable. But there's this additional point. If that were going to be the respondent's position, they needed to plead it so that they could be cross-questioned on it at trial and made to show what they believed when they were using these facilities. It's far too late to start introducing into these proceedings points of that kind. So really, the cross-appeal on quantum merit, with all due respect, is frankly hopeless. So, milady, I haven't quite consumed my time, but unless it would be productive for me to spend more time, please.
Could you just clarify one point for me, which I haven't quite understood? The Italianate Gardens.
Yes.
Is it accepted that there's an easement over there?
No, it's not accepted.
Okay.
I can see that superficially there's a closer analogy with Ellenborough Park.
No, they still tend to get put in brackets, but basically you say in principle they're covered by the same thing. Although if they were standing on their own, then it would be a much stronger case.
It would look closer to Ellenborough Park, but for reasons I've sought to explain, I don't accept that it would attract the communal garden exception.
I think we've asked you all the questions that we want to ask you, Mr. Morshead. Thank you very much. We never object to people finishing early. Never, ever. Yes, Mr. Watkin.
I don't follow, Milady.
Mr. Brown.
My lady, if I may pick up from the very beginning of our written case at page 242, the context of commercial background, in particular, because the nature of the dominant tenement and the subject of the rights granted are critical questions when we come on to the question of whether or not this dominant tenement is accommodated by these rights. I draw to your attention by reference to paragraph 2, 6 or 8 lines down, we refer to a diagrammatic plan from the early 1980s. You have that at page 449, and I mention that not to drag you through the detailed 1 to 21 key on it, although we have a larger print of it available if that would assist, but simply to distinguish it from the plan to which you're referred in the appellant's written case at 466, which is a much more recent plan, as can be seen not least from the fact that it features the diamond lodges which were built some time later. So
what's the page reference to your plan?
The 449 is the approximately 1981 plan, and therefore if you're looking for a plan to assist you as to the state of, in particular, the servient tenement at the time of the grant, that is the one to use rather than the later one. Can I, while there, immediately draw your attention to the inset diagram at the bottom right, which is a small plan of the Regency Villas, which were to be built or perhaps under construction at the time of this plan. Now, at 456 is a bigger and easier to read version of that. At the bottom of 456, one sees, with indeed the numbers of the 26 individual units written in, 25 and 26 above the, I think it's a fountain in the middle of a roundabout there, are the two halves of an existing building, rather grandly known as Elam House, and the other 24 are the purpose-built villas. And I think because, as is obvious from the top of page 455, this document was prepared at a time when Regency Villas were under construction, the photographs of them, in particular at the top of 457, are limited to a photograph which has the existing Elam House in the foreground, and in particular Villas 2 and 3 beyond it, the centre top of the photograph. By looking back at page 456, you will see that Villas 2 and 3, or 1, 2 and 3 to be complete, are those most widely spaced one from another. Whereas all the other villas, if one starts top, centre, 4, 5, 6 and works round clockwise, are built considerably closer together even than Villas 2 and 3 as featuring in that photograph. So it is no forensic sleight of hand to describe these timeshare villas as built in close proximity one to another.
Which the ones under lease, which ones are they?
So where Your Lordship's pen is on 457, in the foreground, on the left is the fountain and a roundabout,
Yes.
and the right is Elam House. Beyond Elam House and closest to it is number 3. To its left is number 2, and it's quite hard with this quality of print to make out villa number 1. The key point is that the two that are photographed there are as widely spaced apart as it gets. All of the others, as is obvious from the plan at page 456, were built in closer proximity one to another. And staying with 456, the right-hand column, immediately below the floor diagram for the rectangular version of villa, there was an L-shaped version and a rectangular version. The text duly says the villas have been specifically designed for timeshare use. And it goes on to say, although it will be for this court to decide whether this is right or not, in the middle of that column of text, no costly sports facilities to provide or upkeep, as these are all complete and paid for by our golf and country club.
But the mansion house, which was divided up into flats,
Yes.
is that what we see on page 450?
at 4. Yes, you see it in glorious Technicolor on.
Yes.
I'm sorry. You see it in. Sorry. Yes, please. We have it in a glorious Technicolor of the postcard at 450, and you see the swimming pool there in the foreground. If you go back to the plan at 449, I may have just a moment, please. Thank you very much. That's very helpful. You can see the swimming pool with the number 13 against it. So that is centrally about 40% up the page with a bit of white space around it. So that's where the swimming pool is. So the photograph is taken, the photograph used for the postcard at page 450 is taken from somewhere between the picnic area numbered 16 and hole number 1 of the golf course. So the photograph is taken at a 45-degree angle from bottom left to top right of that plan. Now, if one goes back to 449 for where Regency Villas are, we see that's the largest of the blocks that's coloured in with a number 21 to the right of it, towards the right-hand side of the page. You see its proximity to the various other facilities, and indeed the squash courts, which are number 8, are actually nearer to Regency Villas than they are to the main mansion house. There are other pictures of the mansion house on page 451 and 453. Now, my respectful submission, assists in understanding the nature of the dominant tenement. For text to accompany it, in particular, you have at 451 to 454 materials that are not, and I should emphasise this, are not specific to the promotion of Regency Villas. They're more about the first stage of the timeshare development, which was the first and second floors of the mansion house, clearly visible in the picture at the top of 453, for example. But, of course, as the recreational and sporting facilities for the first phase were the same as the facilities for the Regency Villas phase, you have the benefit of the textual description of them on the pages from 451 and in particular specifically to recreation and sport 453 and 454. So although 453 and 454 is not a Regency Villas document as such, it is a textual description to go with the diagrams and the limited pictures of the facilities in question. Those are referred to in paragraph 5 of our written case. If I could take you then on page 243 to paragraph 7 of our case, that describes how the Regency Villas emerged as a second phase timeshare development, and it is pointed out on the top of page 244 at the end of paragraph 7 that we have the planning permission, or at least the outline planning permission pursuant to which they were granted, and that is perhaps significant to note. You have it starting at page 446, but the planning conditions start on 447, they have Roman numbering, and continue on to 448. It shows provision that the residential accommodation hereby permitted shall only be occupied as accommodation ancillary to the principal building, Broom Park being occupied under the applicant's timeshare scheme as proposed in association with the principal building. It's unsurprising, the nature of the residential accommodation that you see in these 26 villas built very close to one another and of quite limited facilities within them would not be likely to obtain planning permission to be used as 26 permanent houses in the Canterbury area. At the bottom of page 244, in paragraph 10 of our written case, we then refer to the promotional materials that do relate to Regency Villas. I showed you those a moment ago, and the first two of those, a moment ago, and at 457 to 458, there's a further set, rather clearer set of layout plans for the two types of villas. And on the left-hand column of 457, it is perhaps, there are a couple of points that are significant to note there. About 7 or 8 lines down, the text says, "In this naturally beautiful setting, you'll enjoy everything that makes an exciting holiday resort: golf, tennis, swimming, horse riding, etc. You'll come to escape your everyday pressures and leave renewed and refreshed." And carrying on just for two sentences further on, the mansion house is referred to as the clubhouse. Arriving at the clubhouse, we'll be greeted warmly, etc. And indeed, one sees the reference to the main Broome Park development as a country club. At paragraph 12 on page 245, we emphasise, therefore, the nature, and try to encapsulate in a few lines, the nature of the dominant tenement in this case. And on the same page, at paragraph 15, I won't ask you to look at it because you've looked at it or an equivalent entry with my friends and submissions this morning, that as and when Broome Park changed hands, which in the event it has done 3 times now, these rights all being registered in the charges register of the 2 titles concerned, the existence of such rights, subject to any technical knockout that's available as a result of this case, will have been immediately available to anybody purchasing that land.
What would there have been advised was the position of the covenants to maintain? Because it's clear that as far as the initial leasehold units was concerned,
Yes.
there were rights to use and correlative obligations to maintain.
Correct.
I think that you accept, as far as the villas are concerned, the rights to maintain are worthless.
Yes, once saved contractually, yes, absolutely.
A year after.
Yes, so in this case, 24 hours afterwards. Yes, that's correct, my lord, and I say that the Land Registry got it right when specifically listing those and identifying them as personal covenants on the page.
It's clear that whoever was advising at this time on the drafting of this got it wrong, isn't it?
In that respect, yes.
Well, it's very important if you're going into a major high-class estate to have some right to ensure it's maintained.
Yes, and given that slip, if I can call it that, the position in which it leaves those who have bought the timeshare weeks is that, in effect, they take their chances on the level of maintenance that will take place on the servient tenement. If so a particularly astute solicitor, picking up Lord Sumption's example from this morning, advising one of the 1,300 or so purchasers, would point that out and point out the problem of personal covenant, and in an exploratory discussion with his or her client would point to the fact that you won't be able to enforce that covenant And if they're really astute and they've got the document, they'll say, in 35 years' time, your neighbours in the flats next door, quote unquote, won't be able to enforce it either when their lease runs out. And after that, if the owners don't choose to maintain it in good condition, you will be faced with the choice between decreasing the attractive, or take it to its ultimate point, unusable facilities there, or to have to dig into your collective pockets and fund the improvements yourself. That, to my mind, in my submission, would be the correct advice that this particularly perspicacious solicitor would give.
Okay.
So, to conclude our submissions deriving from that first part of our written case, there can be no doubt whatever that all the parties to the grant, transfer was part of a transfer, of course, and to the associated transactions over a couple of days in November 1981, of which it formed part, fully desired to create proprietary rights in the terms of the grant. And obviously, the "and thirdly" paragraph is the one we're particularly concerned with. For the reasons we explain in Part A of our written case, they intended to do that for considerable commercial advantage, being able to sell 1,300 weeks of occupation for the prices you've seen in the price list. So if they sold at near full price, raising £5 or £6 million in the early 1980s, without having to build any new facilities to go with them, because that had already been done. So the ultimate question I respectfully submit for this court, in this case, is whether there is some technical rule of law which makes it so objectionable that parties should have intentionally tried to create proprietary rights in favour of a freehold by express grant, that English law must refuse to give effect to the parties' clearly expressed intentions, with, of course, the consequence, if that were the conclusion, that the 1,300 or so owners are left to pay charges, whatever are levied, for that which they thought and were told they were getting for free. Now, going into the legal issues to which that gives rise, as you know, in Part C of our written case, we address construction first. And I will take you briefly to some of the points to which we refer there. It starts at 262. If at 263, I may take you to paragraph 63, we do respectfully emphasise the principle that the court should lean in favour of the validity of an express grant. The references, without you turning them up, because of course we didn't have the electronic bundle when this document was prepared, Mr. Justice Dankworth's at 150 is now electronic page 843. It's the bottom line of 263. In the top of 264, Lord Justice Latham, with two future law lords agreeing, that extract is at 1429. Hunter and Canary Wharf is not one that we have copied into the bundle, and to add to those, there is also a relevant dictum in Moncrief and Jameson, paragraph 59, which may be found on electronic page 903. It's quoted elsewhere in the document. So far as this case is concerned, the Court of Appeal dealt with that on page 373. That's judgment paragraph 38. And we respectfully submit that there is nothing wrong with what the Court of Appeal said there, and they're not to be criticised for over-emphasising what Mr. Justice Dankworth said, etc. There's also a second principle of construction in play. That's back at page 265 in paragraph 68 of our written case, which is the general principle of construing grants against the grantor. we give a reference to Mr. Justice Cross, as he then was in Dunn and Blackdown. The electronic page for that is 1237, and I noticed that in Clapman and Edwards, which both parties deal with for other reasons, the same point is made by Mr. Justice Bennett at page 809, that is report 512B to C. And then, with those two principles in play, we would, if I may put it this way, stick up for the judge in terms of his approach to the mere 24 hours point. This is dealt with in writing at page 268 in paragraph 74 of our written case, and perhaps I can deal with it shortly in this way, that we would commend the way the judge dealt with it at his paragraph 29, which is on electronic page 394, to the less enthusiastic view of the Court of Appeal, paragraph 62, the electronic reference for which is 378. There's then the fourth ground of appeal point. That's the suggestion that the Court of Appeal made the rather elementary error of construing a 1981 grant by reference to 2017 social circumstances. My learned friend did not develop orally his submissions on that point, and accordingly it would seem a bit excessive for me to reply orally to that which he hasn't developed orally, so we stand by our paragraphs 75 to 77 and submit that it's quite clear from, in particular, the phrase which we quote in paragraph 76, an easement could either in 1981 or in 2017, ... that the contrast that the Court of Appeal was drawing was between 1865, the year of Mountsie and Ismay, and either 1981 or 2017. At paragraph 79, under the heading Give and Take, we respectfully emphasise the undesirability of exploring what might happen in endless potential hypothetical situations in the future. And we have this sort of factual analogy between Moncrief and Jameson and the present case, because as was pointed out in Moncrief and Jameson, in particular paragraphs 45 and 63, the electronic references for which are 895 and 905, that was a case where actually there had been no practical problems for years until the parties eventually got into dispute about parking for access to Dastor. And similarly, this is a case where the parties managed along perfectly well for some 30 years, as indeed the first and second appellant's own manager said in oral evidence, as mentioned by the trial judge. The practical reality of this case is, save for a bit of push and shove in negotiations about what voluntary contributions the Regency Villas owners would make to the costs of maintaining the estate on an annual basis, at a practical level, there were no problems for a long time. I can then move on page 270, or lower down page 270 for our paragraph 80. In the second sentence of paragraph 80, we put the case about which Lord Sumption questioned my learned friend a few minutes ago, that a sensible interpretation of the grant is that it provides the dominant owners, successors, etc., the right to use the swimming pool existing on the servient tenement from time to time. At paragraphs 85 to 86, so that's on at page 272, we also deal with what any other sporting or recreational facilities says. I think that's one of the points may have been suggested we hadn't dealt with. We deal with it fair and square here. We respectfully submit there are two aspects to that. The first is other facilities which already existed in 1981 but weren't specifically listed. There were several of those. The putting green, the croquet lawn and the riding stables are certainly examples of that. And then secondly, we refer we suggest at paragraph 86 there's a second aspect to the effect of the words any other sporting or recreational facilities, and that is, to put it crudely, to allow for substitutes. And there are examples of that. In particular, at the very bottom of page 272, you see listed the facilities which have been now replaced with a covered hard standing area, which of course is capable of use for a variety of recreations. Accordingly, the conclusion to which we respectfully invite you to come at the top of page 274 in paragraph 90 is that it is simply not necessary, nor we submit desirable, for the words to be construed as narrowly as the Court of Appeal did at its paragraphs 45 and 84, where any substitutes have to be new facilities of the same kind on exactly the same bit of land, subject only to de minimis movements. And we respectfully submit that there is no need to construe the grant so narrowly, and indeed for the reasons that to which Judge Pearl drew attention. If one asks, if one imagines, switching perhaps into contract law language for a moment, an officious bystander saying, well, what happens if platform tennis has gone completely out of fashion in 20 years' time? The idea is that the only thing you can do about that is build a brand new platform tennis court on exactly the same piece of land, is unlikely to have been the party's answer in response to that officious bystander. Then, under the next heading, still on page 274, we address the question of, well, what is the servient tenement? And this is a point for which my learned friend belaboured our case this morning, complaining that we were doing just what Lord Scott had said would have been completely unrealistic in Moncrieff and Jameson, saying if you've got a right-of-way over hundreds of acres, it's a bit artificial to say that all the hundreds of acres are the servient tenement. Well, no doubt in Lord Scott's example, that would be right. We say in this particular case that is not right. And firstly, it's not right because the express grant itself ends with the words on the transferor's adjoining estate. So here, if one at least imagines open in front of you again that diagrammatic plan 449, when one has express grants over a whole number of different facilities spread around the area, the majority other than the golf course, yes, within a relatively confined part of the overall estate, all necessarily, insofar as they're valid, of course, carrying with them an ancillary right, for example, to get to the tennis court in order then to use it, to get to the swimming pool in order then to use it. There is no need to construe this as a whole package of whatever it adds up to, 9 or 10 individual servient tenements, when, following the words of the express grant, it is perfectly possible to construe, to regard the whole of the transfer's adjoining land as being the servient tenement. But, and as it happens, we have a case from Canada which illustrates this point. It is perfectly possible to have an identified servient tenement but with the rights of use only applying to individual parts within the servient tenement. That case is mentioned at the very bottom of page 274, and is the case of Grant and MacDonald. You have that at tab 105, and we can pick that up at electronic page 2127. I'm sorry, the head note is at 2125. I think in this particular case, we can go straight to the judgment conveniently. On 2127, at paragraph 6, we see that this is a neighbour granting rights over a strip of their own at the bottom of their own garden to another neighbour. And at paragraph 6, we see that the subject to the express grant was a strip about 37 feet wide, and that was for the benefit of the neighbour as lot 9. The grant, you will see paragraph 2 of the easement agreement cited immediately below paragraph 6 on page 2127. There was then discussion of the validity of the easement starting on page 2128, but for this immediate point, if we go please to page 2131, at paragraphs 19 and 22, we see the point of which I cite this as an example. The easement, paragraph 19, the easement agreement does not give the dominant owner the use of the strip, or one could read that as all of the strip. Only the contemplated swimming pool and the facilities incidental thereto, this is a case where the swimming pool was never actually built, but a gazebo was built, only that are to be for the sole use of the dominant tenement. The provision for the use of is limited by the words as above provided, and hence paragraph 22, I don't think we should struggle to conclude that an instrument is illegal or unenforceable. I think in light of the balance of the document, we can interpret other improvements to mean things like a swimming pool, but apparently, skipping 3 lines, a gazebo was built. So last sentence, the easement area is for the exclusive use of the servient tenement owners, except for that portion of the area upon which an improvement has been constructed. So insofar as it helps you to identify what the servient tenement in this case is, we respectfully say it is, as the grant says, the transferor's adjoining estate, but of course our rights of user over that are limited to particular areas, just as were the rights of the neighbours who owned lot 9 in the Grant and MacDonald case. From the next page of our written argument onward for some way, so page 275 and following, we deal with a number of points which are specific to the cross appeal, and I will therefore hold back on those until I get to the cross appeal, and invite you please to go straight forward to page 291, where we offer our conclusions on construction in paragraph 145, and following my friend's admirable example, I will not read out loud, but if you would just be kind enough to take a moment and remind yourselves of our conclusions A, B and C, which I submit are made out on the basis of the submissions I have just given you. So even if we had managed to confine our written case to a rather less pages than we have managed, it would inevitably not be practical to deal with everything orally, and I'll try and remember to say this only once. Just because I don't read out a paragraph doesn't mean I'm abandoning it. On the contrary, I will identify anything which I'm abandoning. So move on to the issue, ground of appeal number 1, and the question of accommodation. The law of easements is all or predominantly about facilitating and enhancing the use and enjoyment of land by human beings. The very concept of an easement arises from the human use of land. Therefore, on the foot of 293, we submit in support of that, running over onto 294, that the dicta at A, B, C, D are wholly unsurprising. As to A, my learned friend has already read you that passage from Moody and Steggles, which contains a number of examples within it. I'll touch on those in due course. I won't therefore reread it. At the top of page 295, we have Mr. Justice Dankworth's version of the same. At C, Mr. Justice Ingold Thomas, and at D, the pithy way in which Lord Roger put the matter. So if one starts from that premise, it is wholly unsurprising, as noted at paragraph 152, that there are plenty of recognised easements which are to facilitate the commercial or business activity which goes on the land. So the running of the pub in Moody and Steggles, the running of the petrol station in Clapton and Edwards, if they limited the right to advertising the petrol station's own services and products, and the last example, Platt and Crouch, to which we'll come for other reasons, the right to benefit a hotel on one side of a river in the Norfolk Broads. There was a valid easement to use moorings driven into the bank of the river on the opposite side. So, if I may take you, please, at page 1794 to an extract from Gale. This is the edition current at the time of Ellenborough Park. Sorry? Oh, I'm sorry, I haven't given the volume. It's volume 4, the electronic page where it starts, which I got wrong by one. It's actually 1795, and the... no, it's not. I got the page number right and the tab wrong. It's tab 17, the page is 1794.
And which edition is that?
So this is the 12th edition, 1950, and it's in here for a number of reasons related to it being the current edition when Ellenborough Park was decided. And there's this rather pithy sentence at the top of 1794 on page 30 of the book. The number of modifications of rights, so that's a modification of an owner's right effected by an easement, the number of modifications of rights of this kind may be infinite, both in their extent and mode of enjoyment, as the convenience of man in using his property requires. So accordingly, moving to tab 71 and the first paragraph of the current Gale, the relevant words being on electronic page 1797, about 10 lines down the page.
That's the 20th, is it?
So it's the 20th edition, yes, current one. Paragraph 1, the present edition catches Regency Villas at first instance, but precedes the Court of Appeal judgment. Positive easements can be subdivided into two categories. So third line of sub 1, the first subcategory consists of rights to do something or make use of some installation on the servient land. And what a variety of installations on neighbouring servient land have been held to be the subject of valid easements in English law. One example is a dye house, or later the domestic kitchen of a dwelling in Saddleworth, Lancashire, which was the subject of a valid easement for the washing of clothes and brewing in favour of a neighbouring dwelling. That case at tab 37 is Haywood and Mallew. If it assists for the reference, the electronic page where it starts is 1356. River moorings whether piled into the bed of the River Thames to benefit a neighbouring wharf, or driven into the bank of a river on the Norfolk Broads and used by guests staying at the hotel on the opposite side of the river. Those cases are Lancaster and Eve, one of the examples cited by Mr. Justice Fry in Moody and Steggles, electronic page 932, tab 7, and Platt and Crouch, a much more recent decision of the Court of Appeal, tab 52, starting at page 1557. Lavatories in an office building in Bow Churchyard in the City of London for the benefit of people working in the neighbouring offices. Miller and Empser, tab 46, starting at page 1502. The installation was an airfield at Penderford near Wolverhampton for the benefit of a neighbouring factory manufacturing aircraft originally and aircraft parts. Doughty, Bolton, Paul and Wolverhampton Corporations at tab 24, electronic page 1192. A filleting bay within
Filleting? Oh, yes.
bay within a fishmonger's shop on the harbour at Kiama, New South Wales, for the benefit of the neighbouring takeaway fish and chip shop. Wilcox and Richardson, tab 110, electronic page 2202. And, of course, final example, a pleasure garden created in Weston-super-Mare for the benefit of adjacent and a few nearby houses, which, as you saw at the foot of page 86, electronic page 861 this morning, where the Master of the Rolls had no difficulty contemplating that it could have included areas set aside for tennis or for bowls. We therefore respectfully submit to this court that a decision by you in 2018 to restrict easements to rights which pass one of the four tests which we've gathered together on page 292 in paragraph 147 of our written case, two of which come from the grounds of appeal and two of which come from the appellant's written case, requiring the test of accommodation to be satisfied by benefiting land as land or the land itself, would undermine not only the seminal case of Ellenborough Park, which the appellants are driven by the logic of their own argument to attack, a rather more half-hearted way today than in writing, if I may say so, but it would also undermine whole swathes of the body of case law built up in the past 200 years. And at page 293, on paragraph 150, we identify the rump of valid easements that would be left if you made such a decision. I mean, clearly the right of support benefits land as land. One has cases such as Simpson and Godmanchester, to which I will come, that could be said to be benefiting land as land, the right to go onto one's neighbour's land and open the locks, preventing flooding, assuming on the whole it's not good for land to be flooded. And since writing, but on reflection, it may be that rights of way should be added to this list if those rights of way are necessary to avoid the land being landlocked at all, but not presumably rights of way which just gave a second and easier right of access to a property that was not landlocked anyway. There are also many examples of cases where established easements have necessarily involved the use of chattels by the dominant owner. The clotheslines hung across a neighbour's garden, or close in the language of 1832, in Drewell and Towler. The case is cited at page 260 in paragraph 55E of our case. Second, the fender or hatch, as it was variously called, rested on some brickwork on the neighbour's land and then raised or lowered in a slot as necessary by a miller to maintain the flow of water to his mill in the case of Wood and Hewitt, another of the examples cited by Mr. Justice Fry in Moody and Steggles on page 932, cited in our written case, paragraph 151A, page 294. Thirdly, to return to those domestic properties in Saddleworth, Lancashire, the washing and brewing utensils belonging to the dominant tenement in Haywood and Mallew, tab 37. They are specifically mentioned in the report.
Sorry, what were they?
The neighbouring owner had the right to wash clothes and brew in the other neighbour's kitchen, had to take her utensils there and use them for the purpose, and they get a mention in the report, my lord. Fourthly,
So are those all examples of the utensils brought in by the dominant?
these are examples of the dominant tenement using the dominant tenant's chattels
Yes.
in order to exercise their easement.
Oh, I see. I thought it was the other way. So the clothesline belonged to the dominant
Oh,
tenant.
yes. They said we haven't. It may seem like we've set you a lot of cases. There are a lot more we could have put in.
No, I just...
But I have, of course, you will find that in each of these items are specifically
Yes,
mentioned and are specifically identified as being chattels where there was any debate about it. Fourthly, the signboards in the various cases, including Hoare and the Metropolitan Board of Works, that was Mr. Justice Fry's third example, an electronic page 932, the Princess of Wales pub just to the side of Blackheath Common, which had the right to put a sign on a pole, Moody and Steggles itself, and Clapman and Edwards, where, of course, the claim failed for the reasons previously identified. And if McGarry and Wade is right in its commentary on Hill and Tupper, and I will come to Hill and Tupper shortly and try and deal with this only once, but in McGarry and Wade, the electronic page is 1860. The suggestion is that if the right had been to cross and recross the canal for the benefit of the dominant land, such a right would have been valid, and of course such a right would have needed to include the use of a boat or a pontoon. So with the law of easements dealing with such a remarkable variety of circumstances, such a variety of uses of land, two things should come as no surprise to this court. First, that judges and other commentators have over the years used a variety of verbal formulations to describe the nature of the connection between the enjoyment of the dominant tenement and the rights over the servient tenement, which is required for their easement to be valid in law. And in a long paragraph that starts at page 295 in the electronic bundle, paragraph 154 of our written case, we cite 9 such verbal formulations.
Sorry, can you give me that reference again?
Yes, it's electronic page 295 as the start of the paragraph. The paragraph number is 154, and it cites between A and I 9 cases or Law Commission publications which give different, in some cases slightly different verbal formulations, which certainly in the individual case examples, the judges using language which appeared to fit comfortably with the particular facts of the case. That, I'm submitting, should come as no surprise. We submit that those passages entirely support the trial judge's approach. His findings of fact on this are page 397, paragraphs 41 to 42, but I will come to those in due course. And a 10th item that could be added to this list would be the Court of Appeals. Again, slightly different formulation in this case. You have that at page 377, paragraph 56 of the judgment of the Court of Appeal. My learned friend criticises this and says this is the Court of Appeal muddling up the requirement of that an easement should be capable of grant with the test for accommodation. as you will have seen at page 311, which is paragraph 177 of our written case, we respectfully submit that all the Court of Appeal has done is a matter of convenience, if indeed not elegance in judgment writing, is to move effortlessly from one to the other by picking up the phrase right of utility and benefit. And if one lays that phrase alongside the 9 other examples we've already cited, there's nothing wrong with them doing that. So,
can I just, on
yes.
Ellenborough, are you going to come back to Ellenborough Park?
Well, several times, but do ask now, my lord.
No, it's just that the extracts you have there
Yes.
certainly appear in a very long judgment. Don't include the ones which the other side put weight on about it being sort of appurtenant to the collective garden of the houses. You remember it?
Yes.
Page 175, which arguably is a rather narrower test than the ones that you quoted.
Yes, the only difference between my friend and I on that, I think, is that I would not accept that the references and the facts of that particular case to the garden being appurtenant and being a garden common to all the houses are not ultimately a statement of the test that has to be passed in each case. They are statements of features of the facts in that case which enabled it to pass the test. So that's why I haven't included them in the list of tests.
Well, I was just looking, for example, at
Yes.
page 868, memory stick 868.
I'm sorry, my lord, could I have the page again?
That's 868
Thank you.
in tab
Yes.
15, where the Master Rolls says about 5 lines down, the test for present purposes, no doubt, is that the park should constitute in a real and intelligible sense the garden, albeit the communal garden, the houses to which its enjoyment is annexed. Now, you may say that's comment on the facts of the case, but he does say it's the test.
Well, he does, my lord. Firstly, it can't possibly be the test for anything other than the garden case. And secondly, the key is in the words for present purposes. That is the judge applying the general test to the facts of this garden case. Because, that test is only capable of being applied to a garden or park case, as literally stated there. What we've attempted to do at paragraph 154 is to provide a reasonable range of verbal formulations which I think in virtually, I think all of them are intended to be ones capable of general application rather than being stated in terms that are specific to the facts of the case. For better or for worse, that's what we're trying to do in paragraph 154. As I say, we don't in any way dissent from the Court of Appeal's paragraph 56, and we would be happy for them to be added as a 10th example if that's necessary to show our support. With such an array of verbal formulations available to this court, I have hesitated about whether to add to the list at all, but as it seems a central point, and for what it's worth, we would submit that an acceptable formulation in modern language, picking up all the various cases that have been cited, is that there needs to be a real connection between the dominant tenement and the permitted use of the servient land, and the right granted must enhance the normal use of the dominant, I should say land, having said it was modern language, the dominant land. And the two closest sources for that, from within paragraph 154, one goes back to Bailey and Stevens for this, in particular, the word connection, and the connection has to be of substance. We use the word real for that. Come to the close farming case in a few minutes. The second limb is building on Gale, which is example A on page 296. To provide, as it were, three comments on my own formulation, if I may be permitted. The first is that when one refers to the normal use of land, it would seem that the additional references to normal use and enjoyment doesn't add anything in particular. That it avoids the word benefit with its potential for confusion, which Mr. Justice Warren identified in the Polo Woods case, paragraphs 46 to 47, and it emphasises the factual nature of the inquiry involved. So that I come now to the second of the two things which we are submitting the court should not be surprised by, and for this I can go indeed to Ellenborough Park, this time at electronic page 866 on page 173. It's about 12 lines down, and it's a sentence that starts with the word "it" as the last word or the right-hand margin. It appears to us that the question whether or not this connection exists is primarily one of fact and depends largely on two things: the nature of the alleged dominant tenement, and secondly, the nature of the right granted. Again, that should come as no surprise given the variety of circumstances and the variety of uses of land which are dealt with by the law of easements. Hence, we submit at on page 311, paragraph 177, that a short answer to this appeal is that whether or not the rights accommodate the dominant tenement is a question of fact. I've shown you the Ellenborough Park reference. There's a reference in Gale. You've seen the third line of paragraph 177. The Gale reference, the electronic page, is 1805. There's Polo Woods at paragraph 45. The electronic reference for that is 948. And indeed, for completeness, and I'll come to the close farming case, close farming could be cited for this. The same point is made in paragraph 31 of that case at electronic page 1024. So there are plenty of subsequent statements supporting what Sir Raymond Evershed said at that passage in his long judgment in Ellenborough Park. So although we are entitled to submit, as we do at that 177 to 181, that on the basis of the trial judge's findings, and so far as necessary the Court of Appeal's unpacked and expanded version of the same, that the question of whether Regency Villas is accommodated in the relevant sense by the grant in question is one of fact that has been resolved in our favour. Given that, as I've already submitted, if one compares the various verbal formulations with the language both of the trial judge and of the Court of Appeal, it is clear that neither of them have applied an insufficiently stringent test to do justice to the other side's case.
The nature of the dominant tenement,
Yes.
inevitably it causes one to ask when. Is your submission that it's either the actual or planned nature of the dominant tenement at the time of the grant?
Yes. It's the actual or contemplated. We cited, there are several references to support that, including in Moncrief and Jameson for reference. I'll ask to be helped in due course. I'll give you the paragraph of our written case where we deal with that. And the judge found in this case, inevitably, if I may say that way, given the planning permission that existed and so forth, that the parties well knew what was about to happen to the dominant land in this case. It was within the Gulf Company. One subsidiary was arranging to build and develop a timeshare on effectively its own land, if one looks at the group as a whole. So, nature of the dominant tenement, I've dealt with factual aspects of that already when dealing with part A of our written case. you have that small island of land within the appellant's land. If or when you open the large plan at page 445, that is obvious. One has the terms of the planning permission, one has the diagrammatic plan supported by the text and photographs and internal layouts to which I have already referred you. Therefore, we submit on page 312, paragraphs 181 to 182, both that the findings of fact at both levels below in this case are consistent with residential property cases such as Ellenborough Park and the Australian case of Riley and Pentilla, where there's the well-known dictum set out in paragraph 181 about what is necessary for gracious living. The context of that, in fairness to the judge, is that earlier in her judgment, his judgment, he referred to the properties that were constructed in the development there as being gracious. So that was the link to gracious, rather than a sort of allusion to the 19th century or anything like that. At paragraph 182, a point I apprehend your lordships are very much alive to from questions that were asked both by Lord Sumption and Lord Briggs this morning. These are not ordinary houses. These are timeshare units of a very particular type, close built together in that location. Whereas Sir Raymond Evershed said, this is the last line on 312 to the top of 313, though the reference in the electronic bundle, if you want to check it, is 867, he said that a house is a place where the householder and his family live and make their home. Here we would submit that a timeshare villa is a place where the occupier for the week and his accompanying family or friends go for rest and recreation, or put more simply, a holiday. Or put in the terms of the developer's own leaflet at page 457, you will remember the words, to escape their everyday pressures and leave renewed and refreshed. For these reasons, we submit that the use of the facilities set out in this grant has an obvious connection to the normal use or enjoyment of this dominant tenement. We seek to support the submission that at paragraph 182 that such a case is a fortiori a case of ordinary residential developments by reference to the decision of a 9-judge court of the Supreme Court of Canada in the case of Ducat, to which you referred this morning. I gather the court has the benefit of having an electronic version of Volume 6. It is tab 116, supplemental page 103. This case concerned a development known as Crescent Beach in Vancouver, which comprised a row of houses facing the waters of Boundary Bay. A subset of Boundary Bay was Semiamo Bay, which is referred to in the grant. In between the houses and the foreshore in the true sense, the gap between the high tide line and the low tide line, was an open area of land known as the foreshore reserves. You may remember that from my friend dealing with this case this morning. My friend showed you at supplemental page 106, so report page 612, the terms of the covenant which was construed as a grant. It's the second and whereas on the page, that makes it line 7, I think, and whereas the foreshore reserves shown on the plan mentioned are to be held, drop one line, for the purpose of giving free access to the waters of Semiahmoo Bay to the persons purchasing subdivisions, so forth. And if it's convenient, the shortest way of dealing with this is to jump to the declaration made at the end. So this is supplemental page 124, bottom line, declaration, I should have said conclusion. Conclusion B, the right so granted includes the right to promenade freely across the whole of the foreshore reserves and not merely to cross directly from the edge or front of Lot 38, the lot they were looking at, to the waters of Boundary Bay. So having construed the grant, the Supreme Court of Canada on supplemental page 109, report page 615, turned under the heading the existence of an easement to consider that issue within the case. In view of an answer my learned friend gave Lord Briggs this morning, I need to draw your attention, please, to a point about there being public access to the land in question. So we pick up perhaps 5 lines in. Furthermore, the easement so found did not limit the appellant to a direct passageway between her frontage and the waters of Boundary Bay, but rather consisted of a right to cross over or promenade along the foreshore reserves in total, presumably in common with the owners of all the other lots in Plan 2200, the Crescent Beach development. Such a right, if it exists, would in fact be enjoyed not only in common with the other landowners, but also the general public, who have recourse to the foreshore reserves by reason of the streets running down to the bay and which interrupt or separate the reserves into 4 blocks. Now, for the remainder of the page, it's explained some of the judges, the first instance judge, found that the right was as ultimately construed. The majority in the Court of Appeal of British Columbia assumed that for the purposes of argument. But in any event, you've seen what the...
Sorry, if the public had the right anyway, what was the argument about?
Well, I must admit that question did cross my mind.
And there must be something over and above the public right.
I mean, it's a different starting and ending. Well, the sea is the ending point, but
yes.
The public right started from where certain streets ended. What they were here concerned with was granting rights for each lot owner, which stretched all the way along the beach.
So the owners of Crescent Beach had the right to promenade, no doubt, for the width of the Crescent Beach development. The public, but that was, as it were, an expansion of their right.
And all they had was the right to use a gate at the end of their garden to get into an area which the public were happily using anyway. So. Yeah.
And thanks. I have read quite carefully looking. I haven't found a more sophisticated answer to my Lord's very fair question.
But it wasn't public land, as I understand it, although the public had certain rights.
No, it was not public land, but it was a land to which the public had access, yes. Beyond that, I make no complaint about the question, I just haven't got a better answer, I'm afraid.
It probably doesn't matter.
So, on page 616, a bit below passage, I think my friend cited, firstly, I'll just draw your attention to this. There's the first paragraph on 616, supplement page 110. The second half of that paragraph, there is a requisite relationship between, is cited in the Australian case of City Developments and Registrar General at paragraph 21, and we'll come to that. You then see in the next paragraph Ellenborough Park being cited. In the following paragraph, which starts in the Ellenborough Park case, the court summarised its view of the decision there. The 5th line of that paragraph, the Court of Appeal there found that a right reserved for recreational leisure purchases was within the definition of an easement and as such was recognised in law. And then there are 4 citations of particular passages on particular points within Ellenborough Park, and then these 2 important lines which were cited by Judge Pearl in paragraph 57 of his judgment on page 400. In my view, says Mr. Justice Esty, giving the decision of the court, these observations apply all the more emphatically in the case of a beach pertinent to a resort development. So that's the Supreme Court of Canada attaching importance to the nature of the dominant tenement when addressing the question of the validity of an easement. Similarly,
Pertinent, it's probably a mistype for appurtenant, isn't it?
I'm sorry, my lord, let me...
Just the passage you just cited on page 111.
Yes, one would actually read it that way, I agree.
Yeah.
I respectfully agree, I'm sorry. Jumping back across the Atlantic to Scotland, your lordships may recall the friend cites one sentence from a 1909 Scottish textbook saying that there can't possibly be a servitude to play golf because there would never be a dominant tenement. And we, in answer to that, cite a somewhat more modern textbook on Scottish land law. You have it at, in paper terms, tab 97, in electronic terms, page 2070. This is Professor Gordon's book, which is partly republished in the third edition, but this section is in a second volume which hasn't been published. So this is the most up-to-date version on this topic. And you see on page 2070 the heading benefit to the dominant tenement. I invite you just simply to note that about 12-14 lines in, he refers to the sentence that my friend has cited. Rankin roundly declares there can be no such thing as a servitude of golfing, benefit to a dominant tenement being out of the question. Professor Gordon's own view on the next page and the next paragraph, it's rather more sophisticated. It seems to be a mistake to suppose that one can settle in the abstract the question whether a particular right of strolling, golfing, or anything else can or cannot be a servitude. If the right must benefit a dominant tenement, the question whether it is an appropriate servitude can only be settled by considering it in relation to the tenement with which it is to be connected. And then dropping 12 lines or so, when it is possible to have a servitude right to a water supply to drive a mill, there seems nothing anomalous in, say, a hotel having a servitude right of fishing or golfing, although it may be questionable whether a private house should have it. So we see there the same point that Sir Raymond Evershed made in the passage from Ellenborough Park, saying that the first of the two primarily important factors in deciding the key question of fact here will be the nature of the dominant tenement, and one sees that being picked up in the Supreme Court of Canada and by a Scottish author of a slightly more up-to-date textbook. The second factor which Sir Raymond Evershed...
It's not very up-to-date, is it?
1999? Well, as I've said...
Perhaps that is to Chancery lawyers, perhaps I...
No, I don't complain at all. There is a third edition of that book, but it's gone into 2 volumes. We have the first volume of the third edition, but the second volume, which is to include that bit, has not been published yet. So it is at least the most up-to-date. And even if they were the same date, they encapsulate different views. So the second factor on which the question of fact largely depends is the nature of the right granted. By reference on page 266 to paragraph 71 of our written case, where we list out with gaps between each limb of the grant the elements of the grant, one sees that there is a right to use a number of specified facilities or installations, to use Gale's language. There are also rights to use specified areas of land.
So where are you looking now?
266, my lord, and it's in our written case, paragraph 71.
Yeah.
Simply use it, but I, for my own part, find the gaps between the different elements of the grant helpful.
We don't have a copy of the leases, do we, of the the timeshare units within the main house?
One on the Mansion House. We don't. What we have is we have passages of them cited by Judge Pelling in his judgment awarding declarations from specific performance to the timeshare owners against the developer, in which he held, amongst other things, that they had to build a new swimming pool. So that where you
Do we have that judgment?
Yes, we do.
Oh, we do.
And that's where citations of that lease come not from a copy of the lease, but from a copy of Judge Pelling's judgment.
The lease is in the trial. The lease is in
Oh, I'm sorry, my friend corrects me then.
Well, you give me your reference now.
Well, I've certainly taken them from tab 58 in the authorities.
Yeah.
One starting at 1640 is the front sheet, and that's Judge Pelling's judgment in the 2005 case. His judgment is October 2006, and he quotes from the lease in places. And you mean the trial bundle at first instance? Ah, yes. I'm sorry. My friend says it was in the trial bundle at first instance. I think that may well be correct. In terms of the courts bundle, you've got the key passages in from the lease in that.
Would it be possible to provide a copy of the lease?
Certainly. Anything that's in the trial bundle we should be able to provide.
Thank you very much.
With page 266 open in front of us, the right to use specified facilities or installations exists in respect of the swimming pool, the golf course, the squash courts, the tennis courts, and dropping two lines, and any other sporting or recreational facilities. The use of specified areas of land, one inside, one outside. The inside is ground and basement floor of the mansion house. Outside is the gardens, which the adjective Italianate appears to capture the imagination, has had Italianate put on the front of it subsequently on many occasions. That word isn't actually in the grant. But all of those are, of course, governed by the opening word to use, as my friend mentioned this morning. We submit that recreational uses are not inherently objectionable, provided they do accommodate the particular dominant tenement in question. Whether it's a hotel, in Professor Gordon's example, or a block of purpose-built timeshare villas within an estate laid out as a country club or a leisure complex. Since the case of Ellenborough Park was decided, there has been widespread recognition right across the Commonwealth of easements granted for recreational purposes. And two of those indeed precede the 1981 grant in this case. The first of them is Riley and Pentilla in the Supreme Court of Victoria. And perhaps I will take you to that one and one other, and for the other cases I will simply give you the references in interest of time, unless any one of them captures your particular interest. So volume 5, it's tab 107. We have the case of Riley and Pentilla, which was one of those cited by Judge Pearl, in this case at paragraph 60 of his judgment.
Can we have a page number?
Yes, the page number for the report is 2146, so that's tab 107, and the case related to a residential development conveniently pictured on 2149, where one sees two reserves in between areas of housing, the upper one Summit Park Reserve and the lower one Outlook Park Reserve, and bottom centre one sees lot 36 and I think also relevantly 35, where the defendants who'd, as it were, appropriated to themselves part of the Outlook Park Reserve lived. So the head note on page 2146 includes a quote of the relevant grant, which starts on the fourth line of the headnote and runs to the end of the paragraph. Some phrases, all of which are in the middle of the page as it happens, rather than read the whole lot. Fourth line of the quote, to use and enjoy. Sixth line, the land shown as Outlook Park Reserve. Seventh line, crucially, for the purposes of recreation or a garden or a park. So those are the words of the express grant in that case. A description of the servient tenement is in the next paragraph. So in the middle of the first line, in 1967, the defendants purchased lot 36. A portion of the reserve adjoining 35 and 36 had for 40 years been partially fenced off. It had been originally used as a tennis court, but for many years had been used as a garden with trees, shrubs, decorative stonework and a water reticulation and sprinkler system. On this area there was also equipment for a children's playground, 2 lampposts and 2 clothes hoists. I'm sure doing the laundry counts as recreation, but there we are. The plaintiffs are the registered proprietors of several lots abutting onto the reserve. Held 1, the grant constitutes a right in the nature of an easement pertinent to and for the enjoyment of the lands transferred. At page, there's relevant material obviously in particular 2148 and 2150, but in the interests of time I will go direct, if I may, to 2156. The report shows line numbers, so I can now take those. Line 14. It was then submitted that the grant lacked the characteristics of an easement. Line 22, it was submitted by the defendants that the second and fourth features were missing, just the same 2 as in Ellenborough Park. 2 lines later, the judge said those submissions fly in the face of the decision of Ellenborough Park. And at line 49 to the bottom of the page, the judge says that the reasons in Ellenborough Park apply, and indeed took a point similar to the point we take. So this is line 52 in the report. In my opinion, there is greater certainty to be assigned to the expression the liberty to enjoy the reserve for the purpose of recreation or a garden or a park than the expression full enjoyment of a pleasure ground. So we can then have at page 2158 at the bottom, at the very bottom of the page, the for gracious living quotation, which you've already seen in my report, is set out.
Just read it.
Yes,
The bottom of the first paragraph,
560, certainly. So that paragraph, having regard to the decision of the Court of Appeal at Ellenborough Park on the right granted, it seems to me that the right set out in the instrument of transfers each of the transferees from Keene, the original owner who retained the freehold, was sufficient to found an easement. It was more than a mere personal advantage to the transferee of the lot. It was capable of being the subject of a grant at law. In fact, as already noticed, it was in form a grant at law. For gracious living it has been found, and as that's in our case, I'll just go to the 3rd and 4th lines on 2159. It adds to the enjoyment of the occupation of such house property. Our quotation ends on line 8, so I'll pick up there from a friend. Accordingly, so far as is necessary to find as a fact, I am satisfied on the evidence that the grant constitutes a right in the nature of an easement pertinent to and for the enjoyment of the lots transferred. Insofar as it is a matter of law, the grant, in my opinion, possessed all the 4 characteristics referred to by Cheshire. So in chronological sequence, there's then the case of Ducart. You've seen that already. The tab number was 116. Judge Pearl dealt with that at paragraph 57. Then after the grant in this case, there's another Canadian case, Blankstein and Walsh. Judge Pearl dealt with that at paragraph 58 on page 401. The report is tab 100, page 2082, and the case references, it will suffice if you look at the headnote and from the penultimate paragraph on 2084 to the bottom of 2085. And finally, the conclusion in the middle of page 2087. It was a case that failed on prescription because the use was found to be by consent, but it was clear that the judge was satisfied that the use of a playground was capable of being an easement if there was the prescription was made out. The next case is 1992. It's Grant and MacDonald, British Columbian Court of Appeal. We've seen that briefly for another purpose. Judge Pearl dealt with it again admirably succinctly at paragraph 59, electronic page 401. The one remaining case which I would ask you to look at with me, please, still in volume 5, it's tab 101, electronic page 2090, and it's the case of City Developments and the Registrar General of the Northern Territory, decision at first instance of Justice Thomas. Her decision much cited in textbooks, and to my considerable embarrassment, when we cited this to Judge Pearl, we had failed to observe that it had subsequently been to the Northern Territory Court of Appeal and been upheld 3-0. My mitigation is that the Court of Appeal so closely followed the judge's reasoning that the law reports didn't bother to report it. But it is it was on Osterley, and that's where we have got it from. The case concerned a resort built around Lake Bennett, south of Darwin, in the Northern Territory. Could I ask you to help save time? At 2090 at the bottom, Roman 2 identifies the need for benefiting the land, not just the individual. Could I ask the court, please, on page 2091, to read to itself Roman 4 to Roman 7 of the headnote? Grateful, my lady. There's then a description taking up 2092 and a page and a half afterwards of the various pieces of land concerned by reference to the at time relatively impenetrable numbers of the various registered units, but registered plots. Paragraph 10 towards the bottom of 2092. We can note that the land with the benefit of the easement, in the one particular case, that of Mr. and Mrs. Scarton, and the burdened land, which gets various mentions, is section 152 of the 100 of Howard. That was used, that was referred to as, in due course, the Lake Bennett Resort. If I can take the grant at the bottom of 2092 as the example, there are very slight differences between some of them. One has a right to leave a catamaran and canoes, the other has a right to leave a boat. But the key words, which are the same, are in the last 3 lines of 2092, the right to enter upon and use the land burdened by the easement for private recreational purposes. And for this court's purposes, I will leave it at that. We see on 2094 the side heading, the issues between the parties, the familiar 4 requirements, and at paragraph, we see the citations included Ellenborough Park and Riley and Pentilla, and in paragraph 20, the judge's analysis of the question of accommodation. It started, and it's dealt with quite brusquely. Counsel for the plaintiff submits this is not complied with. Paragraph 21, I consider the easement does accommodate the dominant tenement, does benefit the land, not just the individual. and to this extent fulfills the second criterion essential to an easement. There's the citation from Ducat, which I told you of before. Then the capable of grant starts at paragraph 22 on 2095. There is at 2096, paragraph 29, a substantial citation from Riley and Pentilla, which we've just seen. If the reference helps, the origin of that is on electronic pages 2158 to 2159. At paragraph 32, still on 2096, counsel for the plaintiff raises the concern that in the case before this court, any form of recreation, from horse riding to playing soccer or riding trail bikes, cross-country running, camping, and numerous other activities could come within the definition of recreation. This is the plaintiff's submission, could mean every normal use of land that one could contemplate, could be interfered with or obstructed by some recreational purpose or other. The answer comes at 35 with the definition from the shorter Oxford Dictionary, which is, can readily be compared with the current full Oxford English Dictionary, which we cite, electronic page 336. And at 36, the more general conclusion that there's no reason in law why an easement cannot be granted for recreational purposes, expanded at 38 and 39, and at 41, finally, I agree with the submission that the term recreational purpose is to be construed sensibly and reasonably in the context of rural lakeside recreation, and that she cites examples of what that would entail, and therefore finds in favour of the easement's validity at paragraph 42. The Court of Appeal, the next tab, starting at 2099, recited in some detail, it's technically paragraph 6 on page 2103, from the passages about the conditions of the grant, and then went on to basically to follow and summarise the judgment of the judge at first instance, in particular paragraph 13, the arguments before Justice Thomas and so forth. It continues to summarise the judge through to paragraph 18 on 2109. In my judgment, the decision of Justice Thomas is correct and the appeal should be dismissed. Last line of the page, the present easements form no new category. It's now reasonably well settled that a jus patiandi, skip a line, can be the subject of an easement. A number of cases, three cases you've already seen, and one we'll probably have to deal with now tomorrow, the shopping mall case in the High Court of Australia, Arndale and Kilkenny cited. It is now, says Justice Angel, I think also clearly established that a right of recreation may be the subject of a valid easement, citation from Horsery's Laws of Australia, which you also have. The Chief Justice, back on page 2102, and Justice Bailey agreed that the fact that that overwhelmingly follows the judge at first instance may explain why the Court of Appeal escaped reporting, even though the first instance judge did not. If I deal perhaps in 10 minutes with three cases cited against us, Hill and Tupper, Clapman and Edwards and Close Farming. I'll certainly deal with the first. All of them concern grants purporting to confer economic benefits unrelated to the normal enjoyment of the purported dominant tenement. Now, for the case of Hill and Tupper, I should start by referring at page 298 to 299 to our written case at paragraph 155 to 157, where in addition to the citation from Sir Raymond Evershed, which both my learned friend and I acknowledge as a useful summary. You have some extracts from Gray and Gray's analysis of the case. That occupies page 298, paragraph 155. And footnoted there are both Gale and McGarry-Wade. And I would ask you to look, I mentioned this earlier, at McGarry-Wade's treatment of Hill and Tupper. You have that at tab 74, electronic page 1860.
1860?
1860. Look. Forgive me. Yes. So the paragraph is 27-010, you see in the right-hand margin. The owner of a canal leased land on the bank to Hill and granted him the sole and exclusive right of putting pleasure boats on. As I'm going to show you the case in a moment, I'll skip down to about lines 10 or 11 where the sentence starts, the monopoly. The monopoly which Hill had obtained was therefore a merely personal advantage, not connected with the use of his land as such. The result would have been different if the right granted had been to cross and recross the canal to get to and from Hill's lands, and Tupper's boats had been so numerous as to interfere with it. If Hill had taken a lease of the canal itself, he could of course have sued Tupper for trespassing on it. Similarly, Tupper could have been sued for trespass on the facts as they were by the owner of the canal. Now, without in any way wishing to steal Lord Sumption's thunder, right back in 1956, in the Cambridge Law Journal's case commentary on Ellenborough Park, Mr. Goodison of St Catherine's, Cambridge, observed, in the light of Ellenborough Park, that it seems probable that a modern court faced for the first time with the facts of Hill and Tupper would have no difficulty in upholding the plaintiff's claim to an easement. However, being cautious perhaps about jumping on passing bandwagons, I'm not simply going to immediately say we too think Hill and Tupper's wrongly decided or wrong today. What I'm going to do, if I may, in the time that remains this afternoon, is ask you to turn up tab 38, page 1365, and look at some features of the decision itself.
Just before you do, have you got the page number for the Cambridge Law Journal?
No, that's not before you. I'll arrange for a PDF to be provided. I hadn't intended to put it in. And as I say, I'm not going to say it was wrongly decided, but, well, if the court doesn't want it, that's fine too, but in
No, I should like to see it.
I think I'd like to see it.
Okay, yeah, I'll provide that. But our case, it's 1365 tab 38, and what we say is that fatal to the case, the easement in Hill and Tupper, if the case is correctly decided, was the exclusivity of the right and the ambit of the right.
On
So
the basis,
a right to put boats on the canal would be one thing. A right to have nobody else put boats on the canal would be another thing.
Exactly, Mike.
Is that the point?
And also, my researches in light of the exchanges this morning with the assistance of electronic sources indicate that the Basingstoke Canal, which has its own society now, runs for 32 miles, starting at West Byfleet, passing Woking, Farnborough, Aldershot, and ending up at Greywell near Basingstoke. So this is a considerable right that is being granted on the face of things here. If we see about 8 lines down the page, declaration, the grant is the third line below that, the sole and exclusive... I thought I did, but if I didn't, the page is 1365.
Yeah.
Yes, you did.
Third line, the sole and exclusive right or liberty to put or use boats on a certain canal called the Basingstoke Canal for the purposes of pleasure, and to let the same boats for hire on the said canal for the purposes of pleasure. the way it's out of order, but in the order that it comes, about 8 lines below that in the report, it's interesting that the plaintiff's claim was partly being greatly disturbed in the use, enjoyment and possession of his said right, but also lost great gains and profits which he ought and otherwise would have acquired from the sole and exclusive possession, use and enjoyment of his said right or liberty. So we look at who the competing parties were. They were not the dominant tenement and the servient tenement. They were the dominant tenant suing a third party, namely, 7 lines from the bottom of the page, the landlord of an inn at Aldershot, adjoining the canal, whose premises abutted on the canal bank. The plaintiff, as was mentioned this morning, was a boat proprietor, also occupying premises at Aldershot on the bank of the canal. Dropping a line, by virtue of the demise, claimed the exclusive right of letting out pleasure boats, etc. We have on page 1367, my friend cited Chief Baron Pollock, starting the second line of the short report of his judgment. For these purposes, perhaps Baron Martin's judgment is clearest on the point. Firstly, he says, this grant is perfectly valid as between the plaintiff and the canal companies. That's valid in contract, in effect. But in order to support this action, the plaintiff must establish that such an estate or interest vested in him that the act of the defendant, the pub owner elsewhere in Aldershot, amounted to an eviction. And then dropping 7 or 8 lines, trying to keep it short, if he has been disturbed in the enjoyment of it, he must obtain the permission of the canal company to sue in their name. So we would not, with respect, say that the actual decision in Hill and Tupper was necessarily wrong, insofar as the dominant tenant was unable to sue someone who was not a party to the grant for interference with an easement which purported to give him a monopoly on letting pleasure boats out onto a substantial area of water. As my lady put to me, the position might well have been very different if the right granted was a right either not only in the narrow version that Megarian Wade, perhaps to cross and recross the canal using either a boat or a pontoon, or perhaps a right to put boats onto the water of the canal, all 32 miles of it. To that extent, we would, adopt the possible position put by Lord Sumption in the form of a question to my learned friend. I'm sure my lady and the other members of the court will be devastated to know that you will now have to wait until tomorrow to hear our answer to Clapman and Edwards and close farming.
We shall look forward to that tomorrow morning, but we'll adjourn now.